case that we are hearing this morning is 21CA0045M, State versus Steiner. And we are doing this via Zoom, of course. Your panel is Judge Callahan, Judge Carr, and myself. Each party will have 15 minutes to present their arguments. Attorney Bensing, you, of course, may divide your time if you'd like and reserve up to 5 minutes for rebuttal. Just let me know and I'll keep track of the time for you and let you know as you get close to that. We have read the briefs and we are prepared to proceed. I don't think this applies, but we always have the public announcement that if there are children or victims, well, victims definitely in this case, I suppose, we don't use their names. We just use initials or refer to them in another manner, mother, child, parent, etc. All right, we've read the briefs and we're prepared to proceed. Let me start by asking you, would you like to reserve some time, Attorney
Yes,
Benson?
Your Honor, I'd like to reserve 5 minutes of time for rebuttal.
All right, and I'll let you know as you approach that. You may proceed. Thank you.
Thank you, Your Honor. May it please the court, my name is Russ Bensing. It's my privilege to represent James Steiner in these proceedings. And I want to begin by discussing what this case is about and what it's not about. This case isn't about whether James Steiner was going to commit the acts with which he's charged, which is too bad because I don't think that if that were the situation, I think I'd win because I don't think anybody believes that James Steiner at 75 years old was about to embark upon a life of crime in which he'd murder trustees, dump their bodies in the lake, and blow up garbage trucks. But the statute provides that's not a defense. So that's not an issue in this case. Neither is this case about whether Sergeant Mejia was subjectively in fear. The issue in this case is whether there is any evidence that Steiner caused a reasonable expectation of fear of the imminent commission of aggravated arson, felonious assault, or murder. Now, imminent isn't an esoteric legal term. When we hear that an invasion of Ukraine by Russia is imminent, we're not surprised the next day to see Russian tanks rolling into Ukraine. If the weatherman tells us that a snowstorm is imminent, we're not surprised to wake up the next morning and see snow on the ground. There are all kinds of definitions of the word, but we know what that word means, and we know that it means it's about to happen. So the question here is, what evidence is there that there was a reasonable fear of imminent harm? Now, what I'm going to submit to you is that this isn't just a situation where there is no evidence that anyone feared imminent harm. It's a situation where all the evidence shows they didn't. Sergeant Mejia had been a police officer for 26 years. I think it stretches the bounds of credulity to believe that if he thought that Mr. Steiner was about to engage in any of these acts, if the harm was imminent, he wouldn't have arrested him at the scene. And instead of shaking his hand and not even bothering to go out to check his license number or any other information about him. I think it stretches credulity to believe that if Mejia thought harm was imminent, he wouldn't have contacted the other trustees and told them about this, told them that, hey, there's this man out here and I think he's about to kill somebody, so you better be on guard. I think it strains credulity to believe that Mejia wouldn't have called up Rumpel and said, hey, listen, I've got a guy here talking about blowing up your trucks, so you better make sure that they're taken care of and they're protected.
Counsel, let me just interrupt you in regard to what evidence was presented. When the trustee that received these alleged threats testified, did he indicate that he thought this was just against him or against the other trustees as well?
No, I don't know if he indicated that. It was obvious that Mr. Steiner did not refer to him personally. He referred to trustees. He referred to a trustee winding up in the lake, and that was in Lafayette Township. And obviously, he did specifically refer to Rumpel, blowing up their trucks. So it extended beyond Mr. Mejia. And even if you look at just Officer Mejia, pardon me, even if you look at his reaction to it, what does he do? Yes, he sets up some surveillance cameras around his property, but there's no indication in the record when he did that. What he does do is immediately call Officer Montgomery, Deputy Montgomery of the Medina County Sheriff's Office. But then what does he do? He waits 11 days to provide Officer Montgomery with a statement of what occurred. He waits, Officer Montgomery waits 5 days to go out to Mr. Steiner's house. He finds no one there. What does he do? Does he leave a card? Does he make another attempt to contact? No, he makes no further attempt to contact. He doesn't open an investigation. He doesn't do anything. He doesn't turn it over to detectives. And 6 weeks after the incident, Mr. Steiner is never arrested during that time. He's never put on any kind of surveillance by the police. 6 weeks later, after that incident, he's indicted. And I don't think that anybody would believe that 6 weeks means imminent. So given what the county, the county did in this situation, what the officers did, what everybody did, I don't think that there's any basis for anything, anybody determining that this threat was imminent. And I don't think that the state met its burden of showing the sufficiency of the evidence here. They presented no evidence that the danger was imminent. And as I said, all of the evidence indicates that everybody thought that it wasn't. So if there are no further questions from the court, thank you.
One second, Judge Callahan, do you have anything?
No.
No, Judge Carr, you're okay.
No,
All right.
not now.
Thank you, Attorney Bensing. You'll obviously have your full 5 minutes if you need
Yep.
it for rebuttal. And Attorney Biglucci, we'll hear from you at this point. You're on mute. You're on mute.
Sorry about that. Good morning, Your Honors. I apologize. May it please the court, I'm Vince Felucci with the Medina County Prosecutor's Office on behalf of the state of Ohio, the appellee. Mr. Steiner, of course, was convicted of the crime of making terroristic threat. And his sole assignment of error has to do with the sufficiency of the evidence. Essentially, he focuses on this idea that the threats were not actually imminent. I don't think we disagree on what that definition is. Really, it's the trier of fact's job in every case to determine whether a threat was reasonably perceived as imminent. And whether it actually was perceived as imminent in the first place. I thought it was interesting that Mr. Steiner cited this court's relatively recent case of State v. Klingel, 2017 Ohio 1183, which is a case where this court actually rejected a sufficiency challenge to a making terroristic threat conviction. And I would suggest that the facts of this case are far worse than the facts of Klingel, which this court, as I said, rejected a sufficiency challenge. In Klingel, the threats were made through a Facebook status updates, and through Facebook Messenger to an individual who was not even the subject of the threats. It was an indirect threat. In this case, we know that Steiner made his threats face-to-face and in person to Sergeant Zaja.
Well, let's start with that, okay, counsel. You say that it was a threat. Wasn't this more of an indirect threat, just like some of the other cases that have been cited? He didn't say I am going to make sure your body is in, the lake.
Well, when you
going to blow up.
Sure. Well, when you reference the Chippewa Lake and the trustee in Medina County, everybody knows what you're talking about. That was a very highly publicized case, and it's certainly still something that evokes certain emotions in this county, I think, and it was a big deal. And to invoke that and to say that you may find another trustee there, I respectfully disagree. That is about as direct as it gets. When you're saying that to a trustee's face after ranting about something you disagree with and standing in that trustee's space in their offices. I think that's highly specific and direct.
Counsel, I'm gonna interrupt you again, because with limited time, I know I have questions and maybe the other panel members do too. But in regard to the other trustee, as tragic as that was not a murder situation. He wasn't killed by another party.
Well, ultimately, yes, that's what.
You don't have to get into specifics, but doesn't that make a difference too when you're going to whether this is a direct or an indirect threat?
Well, I think there's been a lot of discussion as to whether that was a murder or not, and I think the trustee's family, for example, I think still believes it was a murder, and that has been very highly publicized. But to invoke that, clearly it's just a very outlandish thing to do, first of all. But and then the idea of talking about your special forces training and your ability to specifically make bombs and things like that, and then say that you could have 4 or 5 garbage trucks and blown up, and noting how easy it is to make a bomb and so forth. And the fact that he didn't raise his voice, I think, is brought up, but I think that can be taken as even more disconcerting sometimes than a person yelling and ranting and raving. I think that can indicate being more serious and of having thought about something, as opposed to just letting your emotions get the best of you in the moment. Sergeant Zasia received no indication whatsoever that Mr. Steiner was joking, nor is this the type of thing that people joke about. I think in terms of Sergeant Zasia not taking these threats seriously or responding as though there was an imminent threat of harm, that argument could not be more belied by the evidence in this case. The evidence showed that literally within 2 minutes of Mr. Steiner leaving, Sergeant Zasia had called the Medina County Sheriff's Office dispatch number and reported the incident. Now, the fact that he's a police officer, I think he testified, is the reason that he did that he knows that number. He didn't just call 911 like anybody else, but clearly he did that right away. He requested an extra patrol at his house because he wasn't sure if Mr. Steiner knew where he lived. He thought it was a good possibility that Mr. Steiner could show up at his house. Then he testified that later on, he still got this in his mind when he's setting up security cameras at his house that he didn't have before, and a driveway alarm. And he did that specifically because of the threats. He testifies specifically because of the threats Mr. Steiner made to him.
Any evidence as to when that was done? I believe Attorney Bensing said there was no timeline on that.
I don't think there's a timeline. I
Sometime
don't.
After the incident, though.
Yeah, but I don't know exactly how far it was after the incident. But he testified in no uncertain terms that it was because of the incident that he was doing this. He wasn't just doing this for some other reason, or that he had previously planned to do it or something like that. No. Again, you have in this case, I was discussing Klingel, and how you had a very indirect threat in that case that was upheld by this court. I think in terms of the specificity of the threats, I think the cases are similar. In Klingel, the threat was to shoot police officers, and one officer.
Hang on. I want to make sure I have the case right. Was Klingel the case with the sole female police officer?
Yes.
who was getting off work at 9 o'clock. How does
Yes.
that become indirect? That seemed pretty specific. I mean, and isn't that something the
No.
court specifically pointed to?
No, I agree. In this respect, I'm comparing this case to Klingel, actually. I think the threat was very specific in that case,
But
and I think it was
thought you
very
said-
specific in this case.
I thought you said that you thought the facts in this particular case, the Steiner case, were even more egregious than the Klingel case.
With respect to how the threats were communicated,
Okay.
because I think it was very indirect in Klingel because it was over social media, whereas in this case it was direct face in person, right? But in terms of the actual substance of what was said, what the threats were, I think it actually is similar in terms of the specificity. In this case, of course, the threat to kill Sergeant Zasia and essentially dump his body in Chippewa Lake.
Well, but again, counsel, I'm going to go back to what Judge Callahan is saying. In Klingel, I think I was on the panel with Klingel, as a matter of fact. In Klingel, the defendant there actually was trying to get other people to join him to go down to the police station and kill some police officers. And he specifically said a female cop that gets off work at 9 p.m. And so here, there's a general statement, it would be awful if a trustee would end up in the lake. And now, obviously, that's concerning, but I don't see that necessarily as a direct threat. And then as in Klingel, I'm not saying it is or it isn't, but I mean, not in regard to actually saying, I'm going to shoot a police officer and I'm asking people to come with me to do it, which is pretty much what a terrorist statute is supposed to deal with, right?
Well, and I would just say to that, threats, whether you believe that's a direct threat or an indirect threat, I don't think it matters, Your Honor, because if you look at the definition of a threat, it's very broad and it can be direct or indirect. If you look at the OJI definition of threat, the proper definition of threat, it is very broad, and I believe I have it here. But essentially, I'm not finding it at the moment, but it does have it's very broad language, Your Honors, in terms of this can be a direct threat, this can be an indirect threat.
And I guess I'm not necessarily disagreeing with you, but I guess doesn't it go to the imminence of the threat? That's the whole point.
Well, and in terms of the imminence, I think it has to do with not whether the actions actually were imminent in reality. It's whether they were reasonably perceived as imminent. So it's not a subjective standard. It's not, he can't come in here and say, I'm a 75-year-old man. I actually, after the fact, I'm going to say I actually, which is what the attorney is doing today. I actually had no intent to do that. That's not the standard at all. It's an objective standard based on his actions at the time, what he did, that objectively, reasonably perceived as imminent. And
but aren't his arguments not what his client is saying, but what the state's witnesses did or didn't do?
And I think that's a big part of it. And he talks a lot about what this Deputy Montgomery did or didn't do, who I think ultimately the testimony, he was a very new officer, and he probably did not do everything the way he was supposed to do it, should have done it. in terms of the way he reacted to this. But I think the far more important question is how the subject of the threat, the victim in this case, reacted to it.
Wait a minute. Is the police officer the subject of the threat, or is the trash company the subject of the threat? What's the subject of the threat here? Both?
It's both.
Okay.
Well, the first threat is to Sergeant Zasia, he's also the trustee, and the second threat is to this trash company.
So, all right.
So yes, he makes.
In his
course,
capacity
they
as
didn't even-
trustee.
I'm
Okay.
sorry. I'm sorry.
Oh,
But
okay.
was there any evidence that any of the trustees were notified about the alleged threat, or that the garbage company was notified about the alleged threat?
I don't know.
Well, I'm just talking about evidence.
Yeah, and I think the other trustees were made aware of this, but I don't know about the garbage company.
Okay, so you're saying the testimony was the other trustees were made aware, but that's it.
I believe so.
Okay,
I-
well, we'll obviously read the record. I'm sorry for taking too much time.
About 30 seconds left.
Okay. So, Your Honors, just to wrap it up, Sergeant Zasia clearly took Mr. Steiner's threats seriously and responded to them as though they posed an imminent threat of harm. And there was sufficient evidence to give the case to the jury in this case, who found that Mr. Steiner did commit this crime of making terrorist threats. And I would respectfully ask this court to affirm the judgment of the trial court. Thank you.
Thank you for your argument. Attorney Benson, you have 5 minutes left for rebuttal. You're muted as well, sir.
I'd like to address that last point. If you look at the record, you read all of Sergeant Zasia's testimony, there is not a shred of evidence that he ever communicated anything about that to any of the other trustees. He never contacted Rumpel about any potential threats to their trucks. Now, I think the easiest way of determining this, whether this was really imminent, is to look through the eyes of Officer Zasia. Now, according to the state, he is confronted with a situation in which a man is threatening his life. A man is threatening imminent death. And here we have a 26-year-old police officer, and what does he do with this information? He shakes the man's hand. He doesn't even bother to follow him out to get any identifying information like a license plate or anything like that. And with Officer Montgomery, I realize the prosecutor wants to throw him under the bus in this situation, but the fact of the matter is that Officer Zasia didn't follow up either. It's not like Officer Zasia is calling up Montgomery and saying, hey, listen, I'm worried here. I'm thinking that I'm going to die any day now. What are you doing about this case? None of that happens here. Now, we know what the definition of imminent is. We have the case law on it. And if your best argument, if the state's best argument is that this is worse than a guy saying at 9:00 p.m., this evening, when a police officer gets off of work, I'm going to kill her. I just don't, I think that, I just don't understand that argument. You decided Klingel, it was very obviously a distinct threat. It was very obviously an imminent threat. You have none of that here. There is nobody here who can say, yes, Mr. Steiner was going to commit this crime that night, the next day, the day after that. You have a situation where, yeah, maybe he's going to do it sometime. We have no idea when. That doesn't satisfy the requirement of imminency. I listened to my colleague's argument the entire time. Not one time did I hear him say, here's the proof that this was imminent.
Counsel, let me just
Not-
interrupt you as well. I noticed that you did not argue weight of the evidence, only sufficiency.
That's
And,
correct.
okay, and usually imminence goes to weight of the evidence. I'm struggling a little with that. Tell me how this is a sufficiency argument and not a weight of the evidence argument.
Because the statute requires proof that the threat is imminent. That's exactly what it says in the statute. If I can pull it up here right now.
No, I understand. I understand
Yeah.
that. I'm trying to figure out how that goes to weight. Or obviously, we have the state has to prove the elements of the offense, but
Yes.
it's not necessarily just the elements of the offense, but does the evidence relate to sufficiency or weight? And that's where
Well,
I'm
I think
struggling.
okay, I'm sorry, Your Honor. I think it relates to sufficiency. I think it clearly relates to sufficiency because that's one of the elements of the offense.
Okay, so you're
The
saying
state
that there
has-
was absolutely no evidence submitted that an objective person would reasonably think that these alleged threats were imminent?
That is correct. I
The
can't.
absence of evidence.
Exactly. Not only the absence of evidence, but all of the evidence indicates the contrary, that nobody believed. I mean, you have a police officer standing there. He's been an officer for 26 years, and we want to believe that he thought his life was being threatened, and he
But you see,
doesn't
now that
arrest
to
the guy.
me, and I'm not picking on you, I apologize.
Yeah.
I'm serious that I want to get this straight. Because when you're arguing that seems to go to weight of the evidence, that it was
No,
not believable, because that goes to credibility. And when you're weighing the evidence.
No, I disagree on that, Your Honor. They have to present some evidence. Okay, in the sufficiency analysis, they have to present some evidence on all the elements of the crime. One of those elements is imminency. They have
Well, wasn't
presented.
there- What about the evidence that, he had the extra patrols at his house and the cameras installed and the alarms installed? Couldn't the jury, viewing that evidence in the light most favorable to the state, couldn't they conclude that those threats were reasonably perceived as imminent based on that evidence alone?
Well, first
do
of
you
all,
get
we have no idea when he installed the cameras. Okay, so if he installed the cameras a week later or 2 weeks later, that certainly falls outside the definition of imminent.
I'm going to let you finish this answer, but you are over your time, but you certainly take the time you need to answer this question.
If I may, if
Sure.
I may, as far as asking for patrols, we don't know if patrols were provided. We don't know if he did patrols because he thought that something was going to happen that time. It's about to take place, and there's no evidence in this record that anybody thought that Mr. Steiner's acts were about to take place. Thank you.
Very interesting case and well argued. So thank you both for that. And thank you for appearing on Zoom on behalf of Judge Carr and Judge Callahan. We do appreciate that. Well, we are going to take this matter under advisement, as you might have anticipated, and we will issue a decision in due course. Of course, the clerk of courts will mail a copy of that decision to each of you on the day it's released. And as I'm sure you both know, the opinions are also posted on the Supreme Court of Ohio's website. Again, thank you for your appearance here today. We apologize for some of the delays that have the technical difficulties we've had today, but we appreciate your patience. Both of you have a good day.
Thank you.
Thank you very much, Your Honor.